Hey everybody, I'm attorney Kyle Kaufman. In this video today, we are going to talk about the actual definition of legal custody. I'll tell you what the definition of physical placement is as well, but it's really important to understand the definition of legal custody. So we're going to talk about legal custody, and we're going to talk about in the context of legal custody in the state of Wisconsin. I have here the family law code, all right? And this gets published every year, and it has all the updates in the law. And anytime I have a question, it's really important, obviously, right? We're lawyers, to go back to the law and advise our clients what the actual law says about these matters. So you hear people talking about custody and what that means, but let's really dig into it here. So I've got it marked, as you guys can see here, so I know where I'm going. Chapter 767 in Wisconsin is where we talk about legal custody. I'm going to read directly from the code book here. And legal custody means the right and responsibility to make major decisions concerning the child, except with respect to specified decisions as set forth by the court or the parties in the final judgment or order. So the major thing in there is the right and responsibility to make major decisions. So what are the major decisions, right? Well, good thing here we have a definition of what major decisions are. So I'm going to read from that. Major decisions includes, but is not limited to, decisions regarding consent to marry, consent to enter military service, consent to obtain a motor vehicle operator's license, authorization for non-emergency health care, and choice of school and religion. So quickly, major decisions, right? Most of those generally don't come up in these divorce cases or in child custody matters where we have contested hearings. I mean, a lot of times people are not really arguing about the right to marry or enter the military or get a driver's license. It's the other ones. Non-emergency health care, school, and religion. And that's where you see the conflict. And then we turn to the concept of joint custody or sole custody. So the definition of joint custody in Wisconsin is this: it's a condition under which both parties share legal custody and neither party's legal custody rights are superior except with respect to specified decisions as set forth by the court or the parties in the final judgment or order. So there we have that language again that says except for those that are set out by the court, where a court might give specific decision-making authority to one parent over the other. So let's talk about what sole custody is. Sole custody, by definition in Wisconsin, is the condition under which one party has legal custody. So very simple. One party makes all the decisions. That's sole custody, joint custody, both parties unless specified by the court. Now, how does that differ from what physical placement is? In Wisconsin, we call custody over that decision-making. Physical placement is where the child actually lives or spends time with each parent. In physical placement, the definition of that is the condition under which a party has a right to have a child physically placed with that party and has the right and responsibility to make during that placement routine daily decisions regarding the child's care consistent with major decisions made by a person having legal custody. All right, so physical placement makes sense. We're talking about physically where the child is versus custodial decisions, which are things of decisions being made over concepts. What I want to now drill down on a little bit is this difference between sole custody and joint custody and how a court might decide that issue. It's important to know that. And again, it's nice that our statutes here in Wisconsin give us a little bit direction on how to decide an issue like that. So the court is going to look at the best interests of the child, and they're going to consider several factors which are also outlined in this code, all right, and in statutes. In a different video, I'm going to get into what exactly those factors are, and I encourage you to come and watch that because that'll be interesting. But the court, in granting joint or sole custody, is to presume that joint legal custody is in the best interest of the child. So when we have a presumption, that's important because you come in and that means that we're going to presume both parents are going to make those custodial decisions. Doctor, religion, non-school activities, right? And it says the court may give sole custody only if it finds that doing so is in the child's best interest and that either of the following applies. So first, a court has to determine it's in the child's best interest to give one party sole custody, and one of these following conditions applies. It could be that both parties agree to sole legal custody. Really rare, honestly, that both parties will agree to that. I don't see that oftentimes coming up, but it does happen that two parties could say, sure, that's fine. One parent will make all the decisions, and they agree to it, and the court grants that. Another time it could occur is if they don't agree, but one party's requesting sole custody, and then the court makes a finding of any of the following: that one party's not capable of performing parental duties and responsibilities, or does not wish to have an active role in raising the child. So that's going to require some storytelling, right? One party has to prove up that one of the parents is not capable of performing parental duties or responsibilities, or doesn't want to have an active role in raising the child. So abandonment would be one of them. So if one of the parents takes off to another state and you don't hear from that parent for months, well, that could be evidence of not having an interest in making a custodial decision. Or, not capable of performing parental duties could include incapacity, mental incapacity. It could include maybe a severe addiction to drugs or alcohol that takes somebody really out of the mix of parenting, or it could be some other condition, maybe even somebody in prison or jail. Could be, but not necessarily. So here's another factor a court could look at, or a basis, I should say, the court could use to grant sole legal custody. It's that one or more conditions exist at the time that would substantially interfere with the exercise of joint legal custody. Say there's a restraining order and two parents cannot speak to each other. It's pretty hard to exercise joint legal custody if there's a restraining order, or some other order that prevents the parties from talking. That's an example. Statutes go on to say that the parties are not able to cooperate in the future. I should say, if they're not able to cooperate in the future, then that would be a reason to deny joint legal custody. And a court could look at a number of reasons for why they're not able to talk to each other. Now, the statutes say this, that if the parties are not able to make decisions together, the basis for that could be there's been abuse of the child, domestic abuse, or interspousal battery. And in those situations, those are tough ones. It creates a rebuttable presumption that decision-making between two parties is unlikely to happen. So if a court makes that finding, then giving sole custody to that parent who was the victim is a potential likelihood there. So important to always go back to the code, the statutes in your state. And here in Wisconsin, I wanted to outline what those definitions were and then what a court looks at in determining whether or not to award joint custody or sole custody. Come back for another video as we dive into what allocation of physical placement is, okay, and how courts actually decide by law where a child should be placed. Thanks.